All rise. Veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du Tribunal Pénal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Monsieur le greffier, appelez.
Registrar, can you kindly call the case, please?
Thank you and good morning, Your Honours. This is case number IT 0367T, the prosecutor versus Vojislav Šešelj.
Merci, Monsieur le greffier.
Thank you, Registrar. I shall ask the prosecution. Oh, may I have the appearances, please? Starting with the prosecution, Mr. Markussen, you have the floor.
Is represented by myself, Matthias Markussen, Ms. Lisa Birsay, Mr. Arthur Traldi, and our case manager today is Angel Langenberg. Thank you.
Thank you, Mr. Markussen. Before reading out the summary of the judgment, on behalf of the bench, I would like to thank all those people who have contributed to making it possible to hold our hearings. And I would also like to thank the interpreters who, for a number of years, have worked hard in this trial, without forgetting, of course, the court reporter who has faithfully recorded everything that was said. I would also like to thank the registrar, who for a number of years has introduced to us the witnesses who have testified here, without forgetting, of course, the registrar here at the hearing, who has always assisted us primarily by providing us all the documents. And I should also like to thank the registrar and the deputy registrar who have helped us and helped the bench to make this happen under the best conditions possible. Without forgetting, of course, the legal team and the judge's assistants who have assisted the trial chamber and enabled this judgment to be handed down today. This legal team was new on the job since it only took up its duties in July 2015, following the departure of other legal officers who went to work for other tribunals or institutions. It took the legal team less than 6 months to review all the evidence on the record to enable the judges to conduct their deliberations under the best possible conditions. Towards the end of the afternoon, most of them will be leaving the tribunal. They will be jobless, even though I had asked for their contracts to be extended for a few weeks, a maximum of 1 month, even though this has not been made possible. But I would like to thank them for all the work they have provided. I shall now begin by reading out the judgment summary. The trial's chamber is sitting today to render its judgment in the case of the prosecutor versus Vojislav Šešelj. In its order on arrangements for delivery of judgment issued on 16th of March 2016, the chamber deemed that Vojislav Šešelj's transfer to The Hague was not required. The chamber did, however, give the accused the possibility of following the hearing via video link from Belgrade. The registry reported that Vojislav Šešelj declined the chamber's offer. That is why he is not here today. I will nonetheless proceed with the delivery of our verdict. What I will now read out is a summary of the chamber's findings. This summary does not constitute a part of the judgment. Only the official judgment, which will be made available at the close of this hearing, is authoritative. As a preliminary matter, I wish to define the scope of our judgment. The Chamber's findings, which I will set out below, do not claim to establish the entire truth about the events that occurred, let alone to recount the complex history of a conflict. The Chamber's role is limited to providing a legal response to the allegations made in support of the prosecution theory. Therefore, this judgment is dependent on the limited truth that may or may not have been established by the facts presented before the Chamber. In the course of this trial, which commenced on 7th of November 2007, the Chamber admitted close to 1,400 exhibits. It heard 99 witnesses, 90 of whom testified for the prosecution, and 9 were called directly by the Chamber. The judgment consists of just over 100 pages and includes 2 annexes, a concurring opinion from Judge Antonetti, I myself, a statement from Judge Nyang, and a partially dissenting opinion from Judge Latanzi. The prosecution charges Vojislav Šešelj, a politician, president of the Serbian Radical Party, and a member of the Assembly of the Republic of Serbia, with having directly committed, incited, and aided and abetted the crimes attributed to the Serbian protagonists in the conflict during the period from August 1991 to September 1993, and of having participated in them through his membership in a joint criminal enterprise. The prosecution's charges rest on the following grounds. The ideology of a greater Serbia. The prosecution claims that the crimes were committed were an integral part of the means deployed to enable all of the Serbs spread out in the territories of the former Yugoslavia to live in a new and territorially unified Serbia. According to the prosecution, this goal was to be achieved through violence, including the forcible displacement of the non-Serbian population living in certain areas that were deemed to be Serbian land. The prosecution's arguments rests on 2 pillars. The first claims that Vojislav Šešelj was associated with the crimes by virtue of his membership in a joint criminal enterprise whose members included local and national authorities, such as the President of the Republic of Serbia, Slobodan Milosevic, military leaders and deputies, as well as paramilitaries and volunteer units called Chetnik or Šešeljevci. Vojislav Šešelj's main role was, aside from war propaganda and incitement to hatred against the non-Serb, characterized by his involvement in the recruitment and organization of volunteers who would be sent into the field and incorporated into units of the Serbian forces, which allegedly carried out attacks in several municipalities in Croatia and Bosnia and Herzegovina. These Serbian forces are claimed to have committed murders, acts of torture, and cruel treatment against numerous non-Serb civilians, notably Croats and Muslims. It is also claimed that they forcibly displaced non-Serb civilians and expelled them. Additionally, they are said to have destroyed villages and committed devastation not justified by military necessity, deliberately destroyed or damaged institutions dedicated to religion or education, and plundered public and private property. The same Serbian forces were said to have imposed restrictive and discriminatory measures as part of a system of persecution. The prosecution does not allege that Vojislav Šešelj was a military leader, nor does it find him criminally responsible under Article 7.3 of the Statute of the Tribunal, applicable to a military or civilian superior. Nevertheless, the prosecution does attribute extensive authority to Vojislav Šešelj, which he also wielded in the conflict zones that he allegedly visited in order to boost the morale of his troops. The prosecution submits that Vojislav Šešelj established a war staff within his party that notably took care of logistical needs and the deployment of volunteers, that he was kept regularly informed of the activities of his troops, that he had the power to intervene with volunteers and to promote them, and that he had even decorated some of them, notably by conferring upon them the rank of voivoda that he himself held. According to the prosecution's second pillar, Vojislav Šešelj directly committed a certain number of crimes, notably through public and direct denigration in speeches inciting hatred of the non-Serbian population of Vukovar in Croatia and Hrvatski in Vojvodina in Serbia, particularly the Croats, and by calling for their deportation from these parts. The final version of the indictment, amended several times, in which all of these charges are included, contain 9 counts, 3 of which are counts of crimes against humanity: persecution, count 1, deportation, count 10, and inhumane acts, count 11, and 6 war crimes, count 4, murder, count 8, torture, count 9, cruel treatment, count 12, wanton destruction of villages, count 13, destruction or willful damage done to institutions dedicated to religion or education, and count 14, plunder of public or private property. Vojislav Šešelj pleaded not guilty to all of the charges. He represented himself and was not assisted by counsel. At the close of the prosecution case, Vojislav Šešelj opted not to call any witnesses or to present additional evidence before the chamber. Nevertheless, he actively participated in the first stage of the trial with a multi-pronged defense strategy, which included challenging the legality of the tribunal and claiming that there was no evidence implicating him in the alleged crimes, and that the charges against him were political or biased. Although, at first, Vojislav Šešelj refused to concede anything to the prosecution, as the trial progressed, his defense strategy seemed to become more nuanced. Vojislav Šešelj endorses and upholds his nationalist ideology for Greater Serbia. However, he does not attribute the same purpose to it or to this ideology as a prosecution. Ultimately, he did not challenge the existence of the majority of the acts of violence, destruction, and plunder committed in the conflict zones. Vojislav Šešelj did at times challenge their scale or motives, but mainly distanced himself from them by insisting that neither he nor his men, recruited as volunteers, were involved in the perpetration of these acts. Furthermore, he argues that once recruited, his volunteers were in any case not under his control because they were directly incorporated into the Yugoslav armed forces, the JNA or the VRS, depending on the period in question, which had their own command and hierarchy, or into local command structures. He pointed out that the war staff of his party, the SRS, which was in fact headed by his deputy, and in which he had no direct role, had no military structure despite sounding warlike. That the distinction of voivoda that he bestowed on some of his men was not a military distinction, nor did it imply any association with the SRS. According to Vojislav Šešelj, some of the volunteers were also local people who were already present at these locations and who therefore had not been sent to the conflict zones by him or his party. Vojislav Šešelj submits, for that matter, that there were several groups of volunteers, some of whom were notorious criminals and had nothing to do with his men. He notes some confusion in distinguishing them. This confusion, according to him, is made easier by the fact that the epithet Chetnik, far from being exclusively applied to the SRS volunteers, was instead rather bandied about. Overall, Vojislav Šešelj presents the Serbs as being the victims of Croat and Muslim aggression. He also points out that the Croats and Muslims respectively initiated an unconstitutional secession that set off a conflict in which the Serbs appeared as the defenders of the law. He defines the recruitment and organization of volunteers as part of a legitimate operation to defend the Serbs, including in Croatia, where the challenge to their status as a constituent people guaranteed by the Constitution, coupled with their harassment and persecution, constituted a serious threat to their existence. Vojislav Šešelj submits that these acts needed to be taken seriously in order to avoid a repeat of the Serbs' tragic past. It is in the same vein that Vojislav Šešelj provided a different description of the context in which he gave his speeches, which in his opinion galvanized his troops and articulated his own political vision and his plan for society, and which the prosecution wrongly qualified as acts of persecution, incitement to hatred and deportation. Vojislav Šešelj also invites the chamber to undertake a critical analysis of the previous judgment rendered before this tribunal, some of which share the same factual basis as his case, notably the judgment in the prosecution in the cases the prosecutor versus Mile Mercic et al. And the prosecutor versus Momcilo Krajšnik. He submits that the total or partial acquittals and the findings that were rejected, including the existence of a joint criminal enterprise and crimes against humanity in certain locations such as Vukovar, must be applied to his case as res judicata. However, he invites the chamber to bear in mind the limited scope of the conviction in the same cases because they were erroneous or were based on grounds irrelevant to his own case. Finally, it must be pointed out that Vojislav Šešelj cross-examined prosecution witnesses and witnesses called by the Chamber pursuant to Rule 98 of the Rules of Procedure and Evidence. In his final brief, he provided a comprehensive summary of the value that he assigned to each individual testimony. On the other hand, he decided not to question the Rule 92 ter witnesses, and for the same reason, he objected to the admission of the written statements of Rule 92 bis and quarter witnesses. Prior to conducting a more detailed analysis of the specific crimes that Vojislav Šešelj is charged with, the Chamber, by a majority, Judge Latanzi dissenting, made a number of observations. The first of which concerns a certain lack of precision in the prosecution's approach. The prosecution initially presented the charges very clearly, starting from paragraph 5 of the indictment, in which it drew a distinction between the crimes physically committed by the accused by limiting them solely to counts 1, 10, and 11, and the other crimes that were allegedly committed through the joint criminal enterprise. This initial set of charges was soon obscured by subsequent allegations. Vojislav Šešelj was ultimately claimed to be a member of a joint criminal enterprise for all the crimes. The prosecution merely includes all of the crimes under primarily the first category and alternatively under the third category. The alleged criminal purpose of the enterprise also seemed to vary depending on the written submissions. To characterize the means of creating a Greater Serbia, the prosecution oscillates between ethnic cleansing and the quest for territorial continuity between the Serbs. The prosecution uses the terms violence and crimes indistinctly, yet these two notions cannot be considered as equivalent, especially since the backdrop of this judgment is a war. A war is by definition violent, without this violence necessarily being a synonym for crime. Some of the prosecution's written submissions give the impression that the very ideology of a Greater Serbia is of a criminal nature, while others focus more on denouncing the means of its furtherance. The prosecution also seems to assume that the Serbian military campaign was illegal, thereby making any distinction between what may have been a legitimate military campaign and a campaign that may have become criminal useless. Such a criminal campaign, which alone would be punishable. Added to this ambiguity are wide-ranging charges, which for the prosecution consist in targeting all the possible modes of criminal conduct provided for under Article 7.1 of the Statutes of the Tribunal, without them necessarily corresponding to the described facts. Thus, the same facts have been qualified as acts of direct commission, acts attributed to a criminal enterprise, acts of incitement, or aiding and abetting. The same facts that I qualified as murder, torture, and cruel treatment, crimes of deportation, inhumane acts, forcible transfer, wanton destruction and plunder of public or private property are also referred to as acts of persecution. overall, the prosecution applies a circular approach in which practically each crime has multiple qualifications, and each mode of participation in crimes seems to contain or superimpose all the others. While cumulative charging is generally permitted on condition that the facts allow for this, in the opinion of the majority, it is much more difficult to accept an indiscriminate use of all the possible modes of liability with almost no regard for the specificity of the facts. The prosecution has been reprimanded for this catch-all phrase in the judgments. The majority regrets the maximalist approach, not in order to claim that it has impaired the proceedings and has compromised Wojslaw's effective defense. It must be emphasized that the latter was able to present all of his arguments. The majority simply underlined that, regrettably, the prosecution's ambiguities complicated an approach that could have been more simple for the prosecution, but also for the defense and the chamber. The defense and the chamber were both chastised to a certain degree for following the furrow dug by the prosecution. The prosecution's briefs should have helped lift some initial ambiguities. On the contrary, instead of presenting the work plan of the prosecution with regard to the facts to be proved, and of reviewing at the end of the trial how the prosecution completed its tasks, the briefs appeared to the majority rather as new charging instruments, each of which was aimed at presenting the entire case of the prosecution. Thus, it is with some difficulty that the chamber has tried to untangle the disparate submissions of the prosecution. I will now present the findings of the chamber on certain important questions linked certain evidence-related questions. The chamber admitted into evidence many excerpts from books by Wojslaw Šešelj. The source of these documents represents for the chamber important indicia of whether the published speeches are attributable to Wojslaw Šešelj. The chamber, however, does not lose sight of the possible exaggeration of some of these statements. The chamber has also admitted into evidence the initial written statements given to the prosecution by witnesses who then partially or completely contradicted their statements when they testified. The chamber followed the guidelines outlined by the appeals chamber and examined the evidence from these witnesses case by case. The chamber admitted considerable evidence that goes to a consistent pattern of conduct. The chamber, by a majority, Judge Latanzi dissenting, did not find it very useful to take into account this evidence, which only duplicated the evidence that had already been admitted on the relevant facts. The chamber received a number of documents and testimonies from other proceedings. For the facts admitted, through judicial notice under Rule 94 bis of the Rules of Procedure and Evidence, the Chamber recalls that their evidentiary value is not binding for the Chamber. Without having been challenged by evidence to the contrary presented by the defense, it is not definitive. The Chamber may set them aside in favor of more reliable evidence, such as a testimony of witnesses who were directly examined by the Chamber and subjected to cross-examination.
Aborder le contexte général des faits visés dans l'acte d'accusation. La Chambre a reçu
the Chamber. I will now broach the general context of the facts in the indictment. The Chamber received ample evidence retracing the chronology of events that led to the disintegration of the former Yugoslavia. Vojislav Šešelj founded the SPO in March 1990, together with Vuk Drašković. Following their disagreements, on 18 June 1990, Vojislav Šešelj founded the Serbian Chetnik Movement, or the SCP, over which he presided. On the 25th of February 1991, Vojislav Šešelj, Ljubiša Petković, and Tomislav Nikolić founded a new political party, the Serbian Radical Party, or the SRS. Vojislav Šešelj was elected as its president. The goals of the SRS were essentially the same as those of the SCP. They called for the creation of a united Serbian state, or of a greater Serbia, that would follow the borders defined by the Karlobag, Virovitica, Ogulin, Karlovac line. The SRS had a twofold structure. A central committee, the organ of the party, and municipal committees and subcommittees at the level of small towns and villages. The SRS also had branches in Vojvodina, Croatia, Bosnia and Herzegovina, and in Montenegro. With respect to the SCP-SRS volunteers, the Chamber found that the concept of volunteer within the Serbian army initially referred to individuals who joined the armed forces in times of war. From August 1991, according to the law on national defense of the Republic of Serbia, the Serbian volunteers had to join the territorial defense in order to reinforce the troops of the Federal Armed Forces, regardless of their affiliation. The Chamber focused on the disputed issue of identifying SCP-SRS volunteers. These men were called Šešelj's men, or Šešeljevci, a name which was sometimes confused with that of Chetniks, which was used, depending on the case, to refer to Serbian soldiers who identified with the nationalist ideology of Vojislav Šešelj. An analysis of the evidence shows that Šešelj's men could be identified by their physical appearance and by their clothing and accessories. Without this method of identification always being decisive. The chamber was therefore careful to identify persons associated with the SCPSRS using various sources, rather than associating any reference to the term Chetnik with Vojislav Šešelj. The chamber found that the recruitment of SRS volunteers primarily took place in the SRS headquarters in Belgrade. Recruitment was also done at the municipal level. It is not disputed that the SRS also recruited and sent volunteers in response to requests from other armed forces, in particular the local territorial defense, or the TO, in Bosnia and Herzegovina and Croatia, and the armed forces stationed in Bosnia and Herzegovina and Croatia, including the JNA, VJ, and VRS. The chamber found that being a member of the SRS
de recrutement des volontaires
was not a criterion for the recruitment of volunteers. Among them, there were also persons without any political affiliation, or whose affiliation to the SRS came after they had been deployed in the field. One of the key findings of the chamber was to note that while Vojislav Šešelj may have had a certain amount of moral authority over his party's volunteers, these volunteers were not his subordinates when they were engaged in military operations. The chamber has ample proof of this, including the testimony of prosecution military expert Mr. Renaud Tonens. He explained quite clearly that, on the one hand, the Yugoslav constitution and other relevant legal text envisaged the possibility of declaring an imminent state of war. Once such a declaration had been made, the army could resort to using volunteers to reinforce its regular troops. The Yugoslav armed forces were organized on the principle of unity of command. By virtue of this principle, both regular soldiers and volunteers were sent into the field and were under the same military hierarchy. On the basis of this principle, Vojislav Šešelj could not have had any hierarchical relationship to the volunteers once they had become incorporated into the structure of the regular armed forces of the JNA, VJ, and VRS. With respect to the prosecution's allegations that the paramilitary forces participated in the crimes set out in the indictment, the chamber received evidence showing that the following paramilitary groups were in fact present during the period relevant to the indictment in some of the locations where crimes were committed, namely Arkan's Tigers, the White Eagles, the Dusan Silni detachment, the Red Berets, or the special unit of the Serbian DB Security Services, which was created on the 4th of May 1991. The Yellow Wasps, the Leva Supoderica detachment, the Vasilije Vidovic, also known as Vaske unit, Gogic's unit, also known as the Loznica group, the Karađorđe unit, the SPO Serbian Guard, the Branislav Gravilović, also known as Brne, and Slavko Aleksić units. Furthermore, the chamber examined the alleged relationship between these groups and Vojislav Šešelj. In the chamber's opinion, with Judge Latansi dissenting, there is not enough evidence to find that an affiliation existed between Vojislav Šešelj and certain paramilitary groups, such as Arkan's Tigers, the White Eagles, and the Karađorđe unit. The chamber also finds, unanimously, that there is no evidence of a direct hierarchical relationship between Vojislav Šešelj and the Loznica group, or the Serbian Guard unit. The chamber further finds that Vojin Vučković, also known as Žučo or Žuca, was the commander of a Serbian volunteer unit, but he operated independently by taking on the name Yellow Wasps. Žučo's brother, Dusan Vučković, also known as Repić, and a person whose nickname was Topola, were also members of this unit. Vojislav Šešelj distanced himself from the Yellow Wasps after the murders committed in Zvornik. With respect to the Red Berets, the chamber found that some SRS volunteers had joined the units of the Red Berets and were even commanders of those units. The Leva Supoderica detachment consisted of SRS volunteers sent to Vukovar by the SRS staff or recruited locally. With respect to Vasque's unit, the chamber found that Vasque was a member of the SCP from its inception and a founding member of the SRS. The chamber finds that from September 1991 to late February 1992, Vasque was an SRS volunteer in Benkovac, in Dalmatia. With respect to Brne's units and Slavko Aleksić's units, the chamber found that these units consisted of SRS volunteers in Bosnia and Herzegovina during the period covered by the indictment, but that Brne and Slavko Aleksić had not been sent by the SIS to the Sarajevo region. Nevertheless, Vojislav Šešelj acknowledged them as being the commanders of the SIS volunteers on the ground. Their units had furthermore been placed under the command of the VRS. I will now summarize the Chamber's legal and factual findings on the crimes set out in the indictment. With respect to the requirements under Article 5 of the statute regarding crimes against humanity, the Chamber, by a majority, Judge Latenzi dissenting, found that the prosecution failed to prove beyond all reasonable doubt that there was a widespread and systematic attack against the non-Serb civilian population in large areas of Croatia and Bosnia and Herzegovina, notably in the municipalities of Vukovar, Zvornik, the region of Sarajevo, and in the municipalities of Mostar and Nevesinje during the period covered by the indictment. The evidence tendered and considered in fact establishes that there was an armed conflict between enemy military forces with civilian components. The majority is of the opinion that the prosecution failed to present the judges with an account that clearly shows that civilians who did not participate in combat were targeted en masse. The prosecution does no more than make general statements that fail to account for the specific evidence heard by the judges. Under such circumstances, the majority cannot dismiss the defense's argument, amply supported by some of the testimonies, according to which these civilians had fled the combat zones to take refuge in villages inhabited by members of the same ethnic or religious group. That the buses that were provided for this purpose did not constitute operations to forcibly transfer the population, but were in fact provided on humanitarian grounds in order to assist non-combatants who were fleeing combat zones in which they no longer felt safe. In the case of Vojvodina, the majority of the chamber, Judge Latanzi dissenting, finds that this area was not a zone of armed conflict. The majority did not note any effort made by the prosecution to argue, let alone prove to the chamber, that there was a clear nexus with the conflict in Croatia and in Bosnia and Herzegovina. The prosecution has not presented any evidence on the conditions under which Serbian refugees arrived from Croatia in order to establish such a nexus. The majority also noted other shortcomings in the prosecution's approach. The majority notes the particular weakness of the evidence presented by the prosecution to establish a nexus between the acts of violence and the departure of civilians from certain areas. The report of expert Eva Dabo merely provides a comprehensive list of the departures that occurred throughout 1992, without specifying the cause behind them. Similarly, witness VS061, upon whom the prosecution relies heavily, was not convincing. He was caught out on a number of occasions and had to admit that his account contained serious omissions and fabrications. These fabrications concerned essential issues such as the murder of a Croat, Mijat Stefanac, which, according to the witness, was claimed to be the event that made the Croats flee. Under cross-examination, he admitted that this murder had been committed in a cafe in the context of a private dispute which got out of hand, and that those responsible for the murder had been arrested and tried. The majority notes that, generally speaking, the violent acts against the civilians in Hrtkovci, such as they have been described, are not comparable in terms of their scale and modus operandi to a widespread and systematic attack against the civilian population. the testimony that has been heard, far from suggesting that there was a large-scale attack against the Croatian civilian population, rather points out acts that were based mainly on local or even private reasons. Their primary reason would appear to be the acquiring of accommodation by Serbs who had none because of their refugee status. Finally, the majority notes, and without neglecting the particularly troubling speech made by Vojislav Šešelj on 6 May, in which he clearly called for the expulsion of Croats, in particular those whom he considered to be disloyal, that it was not alleged that Vojislav Šešelj was directly involved in the exchanges of houses. Yet these exchange contracts are specified as the principal means by which the Croats were expelled from Hrtkovci. At best, the prosecution could have sought to establish that Vojislav Šešelj bore indirect responsibility, not direct responsibility, for acts of persecution. In any event, the majority notes the absence of crucial legal elements to establish any form of criminal responsibility for crimes against humanity. Consequently, the Chamber, by a majority, Judge Latanzi dissenting, finds that the conditions required under Article 5 of the statute have not been met. With regard to the requirements under Article 3 of the statute regarding war crimes, the Chamber notes: the existence of an armed conflict in Croatia and Bosnia and Herzegovina during the period covered by the indictment. 2. The crimes specified in the indictment as violations of the laws or customs of war could have been committed by members of the Serbian forces in order to support the armed conflict, or as a result of that conflict. With regard to war crimes, the Chamber notes that it heard certain evidence on crimes not alleged in the indictment. Given Vojislav Šešelj's right to be informed of the charges against him, the Chamber did not take this evidence into consideration. Furthermore, the Chamber holds that the prosecution has not provided sufficient evidence to establish that the following crimes were committed: the murders in the Crna Rijeka sector, cruel treatment in the form of forced labor inflicted on the detainees at Ovčara farm, the cruel treatment inflicted on detainees in the Vele Promet warehouse, the torture and cruel treatment of the detainees in Sonja's house, in the Semizovac barracks, and at the tire repair garage at the Vogošća crossroad in the Sarajevo region, and the plunder of private property by Serbian forces in the villages of Nevesinje municipality. The Chamber, by majority, Judge Latanzi dissenting, holds that the prosecution has not provided sufficient evidence to establish that the following crimes were committed: the murder of non-Serb detainees on the Žuč Hill near Sarajevo, torture and cruel treatment at the Gero slaughterhouse near Zvornik, and the plunder of public or private property in the town of Vukovar and its houses. The Chamber, by a majority, Judge Latanzi dissenting, also did not accept the charges of wanton destruction or devastation not justified by military necessity of towns, villages, and homes, and of the deliberate destruction of institutions dedicated to religion or education. The majority holds that there is insufficient contextual information on the destruction to allow for an assessment that would take all the factors on the ground into account. The Chamber noted the existence of certain crimes, and it will provide a list of these crimes before determining whether they can be attributed to Vojislav Šešelj. In the municipality of Vukovar, murder, torture and cruel treatment, including sexual assault, inflicted on detainees at the Velepromet warehouse and the Ovčara farm. In the municipality of Zvornik, the murder of Muslim civilians during the attack on Zvornik in April 1992. Murder, torture and cruel treatment inflicted on Muslim detainees at the Ekonomia farm, on detainees at the Ciglana factory, on detainees at the Drinjača Dom Kulture, on detainees at the Karakai Technical School, and on detainees in the Čelopek Dom Kulture. The murder of a large number of non-Serb detainees at Gero's slaughterhouse, torture and cruel treatment inflicted on detainees in the Standard shoe factory, and the plunder of private property from houses belonging to the inhabitants of Zvornik. In the Sarajevo region, the murder of 17 Muslim civilians during an attack on the village of Lješevo. Torture and cruel treatment inflicted on detainees in the Iskra warehouse in Podlugovi, and on detainees in Planja's house, and the plunder of Muslim houses after the attack on the village of Svrake. In the municipality of Mostar, the murder of non-Serb civilians in the dump in Uborak, and in the buildings of the main city mortuary in Sutina. Torture and cruel treatment inflicted on detainees in the locker room of the Vrapčići football stadium, and on the detainees in Sutina. The plunder of private property from houses belonging to Muslims in the Topla hamlet. In the municipality of Nevesinje, the murder of villagers in Presjeka, the murder of Muslims in Breza and at the Kilavci heating factory, the murder of villagers detained at the Zemlje school, torture and cruel treatment inflicted on detainees at the Kilavci heating factory, on detainees at the Zemlje school, and on detainees in the SUP building in Nevesinje.
Résumer les conclusions de la
I will now provide a summary of the Chamber's findings on Vojislav Šešelj's liability for the charges in the indictment.
circonscrite.
The prosecution holds Vojislav Šešelj responsible for the physical commission of crimes in relation to the crimes of persecutions, deportation and inhumane acts, forcible transfer, with respect to the accused's speeches, the commission of crimes as a co-perpetrator, participating in a joint criminal enterprise, or JCE, and instigation and aiding and abetting. Seeking to establish responsibility on the basis of a criminal enterprise primarily requires the identification of a common criminal purpose. If the purpose is not criminal in itself, at the very least, the crimes committed to achieve the purpose must be an inherent element. The majority of the Chamber, Judge Latanzi dissenting, has noted an entire series of shortcomings and cases of confusion. According to the prosecution, the plan for a greater Serbia, advocated by Vojislav Šešelj, contained an implicit criminal element as a result of its aim to unify all Serbian territory in a homogeneous Serbian state comprising Serbia, Montenegro, Macedonia, and vast swaths of Croatia and Bosnia-Herzegovina, which would involve the deportation or forcible removal of the non-Serbian population. The majority has analyzed the evidence admitted on the matter in order to determine whether this definition is tantamount to a joint criminal enterprise. The prosecution lays emphasis on the transfer under Serbian control of targeted territories. This transfer was allegedly planned and included certain common characteristics such as A. Declaring vast areas of Croatia and Bosnia-Herzegovina to be Serbian autonomous regions and taking control of public institutions and local administrative bodies. B. Conscripting volunteers and coordinating the actions of the JNA, VJ, the Ministry of the Interior, MUP, TO, and other formations, and C. Covertly arming Serb civilians, and D. Committing crimes in the field. The majority is of the opinion that the prosecution has given a very partial interpretation of the events it claims demonstrate the existence of a criminal plan for a Greater Serbia or for an entity known by a similar name. By depicting the establishment of Serbian autonomous regions in Croatia and Bosnia-Herzegovina as actions that were part of the criminal plan for a Greater Serbia, without clarifying the broader context in which these actions were taken, namely the secession of both Croatia and Bosnia-Herzegovina, the prosecution gives an interpretation which at best hides the way the events unfolded and at worst distorts them in relation to the evidence presented to the chamber, which was mainly prosecution evidence. The majority considers that the plan for a Greater Serbia, such as it was advocated by Vojislav Šešelj, was in principle a political plan, not a criminal one. For Vojislav Šešelj, only the Serbian Radical Party pursued the objective of a Greater Serbia, which was to include all the Serbs, whether they were of the Orthodox, Catholic, or Muslim faith. The statements Vojislav Šešelj made about his vision of a Greater Serbia do not seem to have been contested by the prosecution. Moreover, such statements can be found in numerous documents drafted prior to the proceedings in this case. Even if certain attitudes thought to be discriminatory on the part of the Serbs are taken into account, namely the establishment of their local institutions in Croatia and Bosnia-Herzegovina, the majority holds that the totality of the evidence does not lead to the conclusion that declaring the autonomy of the Serbian people of Croatia and Bosnia-Herzegovina was the result of a criminal enterprise. In fact, it is not in dispute that Vojislav Šešelj was driven by an ardent political ambition to create a Greater Serbia. Nothing, however, indicates that there was a criminal purpose in sending volunteers. There is a reasonable possibility that the sending of volunteers was aimed at protecting the Serbs. The evidence shows that the recruitment and deployment of volunteers by Vojislav Šešelj and his party and the cooperation therein with other Serb forces, including the JNA and VJ, the MUP, the TO and the other paramilitary formations, did not constitute an unlawful activity. On the contrary, it could have been amply justified by the context of war.
En ex-Yougoslavie,
The legal framework of the former Yugoslavia allowed resorting to volunteers. These were integrated into the armed forces of the SFRY, including the Yugoslav People's Army and the Territorial Defense. Moreover, the Chamber notes that Vojislav Šešelj was not the hierarchical superior of the volunteers deployed on the ground. The above findings do not by any means presume to underestimate and even less to conceal the crimes committed in different localities in Croatia and Bosnia-Herzegovina, in which the volunteers deployed by Vojislav Šešelj or his party may have taken part or have been indirectly involved. The majority simply notes that it is not satisfied that the recruitment and subsequent deployment of volunteers implies that Vojislav Šešelj knew of these crimes on the ground, or that he instructed or endorsed them. In the opinion of the majority, these crimes cannot be considered as an inherent element of the political design of Greater Serbia or the activities aimed at protecting the Serbs. The Chamber has received an abundance of evidence establishing that the local Serbs of Croatia and Bosnia-Herzegovina were arming themselves. Nevertheless, evidence shows that Croat and Muslim civilians were equally arming themselves. In the view of the majority, this global picture gives credence to the reasonable possibility of a scenario in which all the warring factions were preparing themselves for the imminent hostilities in order to preserve the lands they considered as theirs, rather than a singular and unilateral step of the Serbian occupiers, driven solely by the criminal purpose of expelling the civilians of other ethnic groups. The lack of evidence of a criminal purpose is in itself sufficient to reject the allegation of a criminal enterprise. The majority explored further, albeit superfluously, the issue of the identity of views between the alleged members of the criminal enterprise, this being a necessary element for the finding of existence of a joint criminal enterprise. The prosecution focused most of its allegations on the identity of views between Vojislav Šešelj and Milošević as representing the JNA VJ and the Serbian MUP, between Vojislav Šešelj and other members associated with Republika Srpska and the Army of Republika Srpska, and between Vojislav Šešelj and other paramilitary groups such as Arkan's Tigers. In its judgment, the Chamber cited the exchanges that took place between the different protagonists in the Milošević trial during Vojislav Šešelj's testimony in that case. It appears from these exchanges that the judges in that case were as much as at a loss as the majority of the Chamber in the present case as to the object of the alleged criminal purpose. The prosecution first stated that Milošević did not share the ideology of Greater Serbia. It was then confronted with its own earlier written submissions, from which it transpired that the notion of Greater Serbia lay at the very heart of its own case. The prosecution prevaricated, changing versions more than once, all the while refusing the adjournment willingly offered to it by the judges so that it could take its time and clarify its submissions that were found to be confusing. In the view of the majority, not only does the confusion remain, but a lot of the evidence shows that the collaboration was aimed at defending the Serbs and the traditionally Serb territories, or at preserving Yugoslavia, not at committing the alleged crimes. The chamber, by a majority, Judge Latanzi dissenting, therefore finds that the prosecution has failed to prove the existence of a joint criminal enterprise. The chamber, by a majority, Judge Latanzi dissenting, also rejects the responsibility of Vojislav Šešelj in terms of the actual commission of the crimes of persecution, with all the consequences of its finding that the standards for applying Article 5 of the statute have not been met.
La Chambre
The chamber unanimously finds that Vojislav Šešelj is not responsible for the actual commission of expulsions and inhumane acts, forcible transfer, as crimes against humanity charged in the indictment. I will now summarize the findings of the chamber regarding the prosecution's allegations of incitement to commit crimes with which Vojislav Šešelj is charged. Firstly, the chamber accepts that the propaganda of a nationalist ideology is not in itself criminal. It deemed, however, that it was its duty to analyze and to qualify the statements made by Vojislav Šešelj and their potential effect on the perpetrators of the crimes charged in the indictment, in the light of their context. The chamber examined the substance and the context of several incriminated speeches by Vojislav Šešelj specifically. 1. A speech delivered on the Vukovar Road on 7 November 1991, where Vojislav Šešelj allegedly stated that, quote, "Very soon there will not be a single Ustasha left in this area," unquote. 2. A speech delivered by Vojislav Šešelj in Vukovar between 12 and 13 November 1991, where he is said to have stated that, quote, "Not a single Ustasha must leave Vukovar alive," unquote, and, quote, "Ustashas surrender. There is no need to lay down your lives anymore," unquote. 3. A speech made in Mali Zvornik in March 1992, during which he is said to have called upon his Chetnik brothers to take revenge against the Balias and pushed them back towards the east, far beyond the Drina River. 4. And a speech delivered on 6 May 1992 in Hrtkovci, Vojvodina, when Vojislav Šešelj allegedly stated that there was no place for Croats in Hrtkovci. The chamber finds that the speeches on the Vukovar Road and in Vukovar were indeed made by Vojislav Šešelj. However, the majority, Judge Latanzi dissenting, could not rule out the reasonable possibility that these speeches were made in a context of conflict and were meant to boost the morale of the troops of his camp rather than calling upon them to spare no one. The chamber, by a majority, Judge Antonetti, that is to say myself, dissenting, also finds that Vojislav Šešelj did indeed deliver the said speech in March 1992 in Mali Zvornik, even if it considers that the precise circumstances of the speech have not been established. The chamber, by a majority, Judge Latanzi dissenting, was nonetheless unable to find beyond all reasonable doubt that in calling upon the Serbs to cleanse Bosnia of the Pogani and the Balias, Vojislav Šešelj was calling for ethnic cleansing of Bosnia's non-Serbs. The majority, in fact, believes that the evidence supplied by the prosecution is not sufficient to exclude the possibility, in view of the context, that in making this appeal, Vojislav Šešelj was rather participating in the war effort by galvanizing the Serb forces. The chamber, by a majority, finds, Judge Antonetti, that is to say myself, dissenting, that the statements made by Vojislav Šešelj in his speech in Hrtkovci constituted a clear call for the expulsion or forcible transfer of Croats from this locality. Nevertheless, the majority, Judge Latanzi dissenting, is of the view that the prosecution failed to show that this speech caused the departure of the Croats or the campaign of persecution alleged by the prosecution. The chamber, by a majority, Judge Antonetti dissenting, finds that two other speeches delivered in the Serbian parliament on the 1st and the 7th of April 1992 constituted clear appeals for the expulsion and forcible transfer of Croats. In the first speech, on the 1st of April 1992, while debating a draft law on refugees, Vojislav Šešelj stated, I quote, "We are going to expel the Croats, exercising the same right that Tudjman exercised to expel the Serbs. We are not going to resort to genocidal activities because it is not in the blood of the Serbs. We are not going to start killing you, of course. We are simply going to pack you into trucks and trains and let you get on with it in Zagreb." End of quote. The second speech of 7 April 1992 reiterates substantially the same. Even though, in the view of the majority, Judge Antonetti dissenting, these speeches were appeals for expulsion, a different majority, Judge Latanzi dissenting, holds that these statements, forming part of an opposition to the official Serbian policy, were an expression of an alternative political program that would never be put into place. The prosecution did not offer anything to show its impact. The lack of any measurable impact, combined with the certainty that the appeals to Serbian authorities to use reprisals against Croats were never favorably received, do not allow the majority to find that there was incitement to war crimes, even when taking into account the most virulent speeches such as the one in Hrtkovci and those delivered before the Serbian parliament. The chamber, by a majority, Judge Latanzi dissenting, therefore finds that the prosecution has failed to show a causal link between Vojislav Šešelj's speeches of the 1st and 7th April 1992 and the crimes committed in April 1992 in Mostar, Zvornik and the Sarajevo area, or that Vojislav Šešelj could be held even indirectly responsible for the crimes committed between May 1992 and September 1993. Under these circumstances, the majority is unable to qualify Vojislav Šešelj's speeches of the 1st and 7th April 1992 as physical acts of incitement. The chamber, by a majority, also rejects the prosecution's allegation of incitement to crimes on the basis that Vojislav Šešelj failed to take steps to punish the Šešeljevci who had taken part in crimes against non-Serbs. The majority recalls that no formal or de facto hierarchical link was found to exist between Vojislav Šešelj and the volunteers involved in the crimes charged in the indictment. Failure to punish, however, cannot be invoked in the absence of any hierarchical link that would make Vojislav Šešelj responsible for the volunteers' conduct. In the view of the majority, it is established that in terms of their actions on the ground, the volunteers were under military authority. With regard to the alleged responsibility of Vojislav Šešelj on the count of aiding and abetting, the Chamber by a majority, Judge Latanzi dissenting, rejects it, noting that the underlying allegations of the prosecution have the same factual basis as its allegations on his responsibility under the joint criminal enterprise and incitement. I will now read the disposition. For the reasons summarized above, the Chamber rules as follows. On count 1, persecutions as a crime against humanity, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 4, murder as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 8, torture as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 9, cruel treatment as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 10, expulsion as a crime against humanity, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 11, inhumane acts, forcible transfer, as a crime against humanity, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 12, wanton destruction of villages or devastation unjustified by military necessity as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 13, destruction or willful damage done to institutions dedicated to religion or education as a violation of the laws and customs of war, the majority, Judge Latanzi dissenting, declares the accused not guilty. On count 14, plunder of public or private property as a violation of the laws and customs of war, the Chamber unanimously declares the accused not guilty. With this acquittal, on all the 9 counts of the indictment, the arrest warrant issued by the Appeals Chamber on 17 June 2015 is hereby rendered moot. Following this verdict, Vojislav Šešelj is now a free man. Judge Antonetti provides an assenting opinion. Judge
L'audience est
Judge Nyan attaches a declaration. Judge Latanzi attaches a partially dissenting opinion.